So New York had 2 petitions for custody of the subject child, and Pennsylvania had a petition for a protective order. Domestic relations law simultaneous proceedings requires the courts to communicate with one another. Domestic relations law provides the parties an opportunity to be heard when there are simultaneous proceedings. Monroe County Family Court failed to provide both parties the child custody proceedings an opportunity to be heard with the communications between New York and Pennsylvania. There is nothing within the record concerning the communications between the courts, and Monroe County Family Court unequivocally used the communications between the courts in rendering its wrongful order of custody to petitioner respondent father. This court was then forced, this is her words, to conference the matter with Pennsylvania Court of Common Pleas Judge Piniella, who agreed to modify his order to allow father's visitation. There is nothing within the record concerning the conference, nor an opportunity for the parties to participate in said conference, depriving Dees of the opportunity to be heard in due process of law. The court treated Dees' application in Pennsylvania as parental alienation, which is a drastic factual conclusion without knowing what was conferenced between the 2 courts. Petitioners Exhibit 1 and Exhibit 2 were TikTok videos admitted into evidence. Petitioners Exhibit 1 was used wherein Dees stated she stopped the phone calls. The court further used the TikToks to find respondent appellant engaged in parental alienation, which is abuse of discretion by the lower court. Petitioner Exhibit 2 is another social media posting, again from TikTok transcript. The video was again admitted into evidence despite lacking proper foundation, being irrelevant and unfairly prejudicial against Dees. The video consisted of Dees saying her mother was her nanny and her father her security. It's sarcasm. The video further went on about Dees talking about planning the child's birthday party and Dees not telling Contreras about the party. Petitioner's Exhibit is a Facebook post made on May 27th. This post predates the birth of the subject child, making it irrelevant and unfairly prejudicial for admission. There is also a lack of foundation concerning Dees' social media privacy questions or settings. The posting concerns Dees stating she's identifying Quaid Batts as the unborn child's father and will know him as father. The child was not even born when this post was made by Dees. The post talks about Dees and Batts having a stepdaughter and then mentioning the unborn child will know Batts as a father. The court took the literal meaning of the post that Dees considered Batts as the father to the unborn child. The post is ambiguous as Dees mentions the stepdaughter and father. Dees meant that Batts will be father figure stepdaughter to the unborn child. The Monroe County Family Court gave this Facebook posting too much weight when it's simply nothing more than a rambling at the juvenile legal system, and Dees posting a stream of consciousness across social media. Petitioner Exhibit 4 is a TikTok video of Dees on October 18th, 2023. There is no proper foundation questions asked by counsel. And admission of this video is an abuse of the trial court's discretion as it is highly unfairly prejudicial to Dees. In the improperly admitted video, Dees stated her belief and fears that petitioner would not return the child after parenting time. The video further purports where Dees stated she is not anchored anywhere. Petitioner's Exhibit 5 is a further TikTok video from March 4, 2023, which predates the birth of the child. The court admitted the video into evidence over objection and its abuse of the trial court's discretion. The video is irrelevant and lacks foundation as to the privacy settings and is unfairly prejudicial towards Dees. Petitioner's Exhibit 7 were text messages between the parties admitted into evidence. Dees' counsel objected to the introduction of these text messages as there was already testimony concerning the same, thus making the text messages duplicated in an abuse of the discretion of the court by admitting into evidence. I will just hand the exhibit over and let the court review it and move on, was the statement made by petitioner appellate's attorney. No questions were asked of the